look at the question which was being referred at paragraph 58 of NN Global. And then, my lords, I had shown your lordship some portions of the Stamp Act, various provisions of the Stamp Act have been shown to my lords, and some judgments under the Stamp Act to show, my lord, that it's the instrument and not the document which is the subject matter of the stamp duty, and that it is really a fiscal matter. And, my lord, the existence and validity of the transaction or the agreement is not put in doubt if a document or instrument is not stamped. And ultimately, my lord, I had also submitted that in view of the interpretation that I was seeking to, my lord, advance, there will really be no revenue loss, because it is the arbitrator who will protect the interest of the revenue as he can, my lord, under 33 and 35.
Have you looked at the decisions under the 1940 Act?
Yes, my lord. I'll come to that, my lord. There is only one judgment which talks of stamp duty. There's a 1940 Act. 21 Calcutta. I'll come to that, my lord, in a moment. There is only one judgment. There is no real case of stamping or stamping. Lordship knows under the 1940 Act, there are various chapters. There is Chapter 2 arbitration without intervention of court.
That's right.
Then Chapter 3 arbitration. Chapter 2 is two, my lord. Then 3 with intervention of court. 4 arbitration in a suit. So, my lord, that regime is slightly different. I'll come to, my lord, that at the appropriate stage. My lord, so your lordships had a look at the Stamp Act, and, my lord, today I wanted to place, my lord, the relevant provisions of the Arbitration and Conciliation Act. Yesterday, your lordships had a look at some of the sections. Section 2, subsection 3, your lordships had a look at 5, 7, 8, and 11. My lord, these are sections that your lordships have already seen yesterday. I'm not going to repeat, my lord, on those 4, 5 sections. 2, 3 is on arbitrability. Section, my lord, 5 is non-intervention, non-obstante clause. 7 is the arbitration agreement. 8 is stay of proceedings, my lord, now reference to arbitration in a suit. 11 is appointment of arbitrator, which your lordships have seen. 11.6a, 11.6b, 11.13, my lord, which says you have to dispose of it within a very short time. So those provisions your lordships have seen. So, my lord, I pick it up from section 16, which according to me, my lord, is critical in deciding the reference, because, my lord, 11 cannot be seen in isolation. It has to be read along with 5 and in particular, my lord, 16. And I would respectfully submit, my lord, now after the 2015 amendment, 16 is to be given its full play. 16 must be given full play, my lord. It was curtailed in SBP. That SBP judgment has been legislatively overruled. 16 has to be given full play. Your lordships will first see 16, then, my lord, the model law on 16, just by way of contrast, and then 2 paragraphs of Justice Thakkar on section 16.
Yeah.
And that is the thread which has been picked up, my lord, in the NN Global matter in the 3 judgment. Let's get out that 21.
Yeah.
Get that. Hold on, may I just read section 16, because it is very, very critical to the argument of the scope, of the narrow scope of section 11 now. 16 says competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement. So existence is covered, validity is covered, and it is an inclusive thing. So other aspects are also covered of jurisdiction, which may not be necessarily only existence or validity. So the word is including. And for that purpose, an arbitration agreement which forms part of a contract shall be treated as an agreement independent of other terms. No, this is the principle of separability and competence. And B, a decision by the arbitral tribunal that contract is null and void shall not entail ipso jure the invalidity of arbitration clause. Well, the 16.
Banerji, is it a coordinate jurisdiction really? Because section 16 starts with arbitral tribunal may. Does it exclude 11.6?
Well, Lord, it does not exclude 11.6. But there is the overlap, my lord.
Then what is your argument? That as a matter of prudence and practice, 11.6 court should avoid looking at this
My lord,
particular point.
there is some overlap between 11.6 and 16. The overlap is only qua the word existence. That's the first point, my lord. 11.6a only talks of existence. 16 also talks of existence. There, my lord, there is a judgment of your lordships in Praveen Electricals, which I will come to, Justice Nariman's judgment, which says that even qua existence, the 11.6a court will only make a prima facie determination and refer the matter even of existence to the arbitral tribunal. So, my lord, the overlap is very minor, and even where there is an overlap, it is as per the jurisprudence of this court, my lord, even existence prima facie is to be.
So 11.6a is examination of existence.
That's all.
So what kind of an examination you are expecting under the 11.6a?
My lord, there is that Praveen Electrical judgment, my lord, a prima facie examination.
We will have to understand what is the scope of examination.
Yes, absolutely.
Mr. Banerjee, we are 5 of us here.
Yes, my lord.
So not necessarily we are bound by
Not at all, my lord.
any other.
Not at all, my lord. But I will show, my lord, the legislative history of 11.6 to show what was the intention of bringing in that provision. Certainly, your lordships can say, no, I want to, in 11.6, I want to finally determine, say, existence. It may be, my lord, your lord.
Because the scheme of Stamp Act is not finally determined. Scheme of Stamp Act is call for the document, impound it, send it for valuation and 10 times penalty.
My lord,
So
there,
this is also a kind of administrative measure, quasi-administrative measure through the
my
judicial
lord,
forum.
there also, my lord, moment we come to, my lord, the question of
Because
judicial and
when we are-
administrative, my lord, we get into a little bit of a
1
problem.
minute, 11.6 court is looking at whether an arbitration agreement is there or not.
Yes,
That is the only scope.
right.
Now the document it's looking at becomes inadmissible, presumably inadmissible in evidence because of non-stamping.
My lord,
Because the
there I would-
requirement of stamping is not being questioned. At what stage we
My
look
lord,
at that?
The question there is, your lordships, there is one intermediate step, if I can, my lord, put it.
Just wait.
There is an intermediate step.
The meaning of inadmissibility we'll have to interpret.
Yes, my lord, before one gets to inadmissibility, so there is, my lord, let us play this out. There is a document which has come to me. I am a section 11.6 judge. I have to decide whether an agreement exists or not. Now, my lord, in the process of this decision, I have to look at this document,
Yes.
right? Now, my lord,
If it is not an admissible document,
now, my
then
lord,
whether we
just
look at it or
if
not.
we pause here for a moment. Now, my lord, to decide on whether this is admissible or not, I have to examine whether or not this document requires to be stamped. This is what is being put to me, my lord.
Yes.
My lord, I am submitting that scope of inquiry or scope of examination is excluded. My lord, the word examination is used in two sections. 11.6 also uses the word examine.
No, 1 minute. If an argument is advanced that an arbitration agreement does not require stamping, then possibly it becomes examination. But if the view is that the arbitration agreement requires stamping,
May not, my
and
lord.
on the face of it,
There may
we see
be,
it's
I'll
not-
give an example, my lord. There may be an arbitration agreement in a document which may be otherwise exempt under the Stamp Act. So, my lord, the very
as,
fact,
for example,
my lord, certain government documents, they are exempted. I'm giving-
government need not pay stamp
Yes.
duty.
So, my lord, the very fact of examination of a document, because then your lordships will have to decide number of things. Not only whether stamp duty is to be paid. Number two, who is to possibly pay the stamp duty. 3, how much will be the stamp duty? For instance, in this case, this present case, my lord, there is a dispute. One party says the other party should pay. The other party says one party should pay. There is a dispute as to quantum. This court said pay 8 lakhs. My learned friend possibly correctly says it is not such a document which falls under X entry or Y entry. I will only get away with paying 500 rupees or whatever. So, my lord, the question is not to reach the stage of admissibility. You have to examine a document, and that examination is for the purpose of establishing whether or not it is to be stamped or not. My lord, whether that examination is to be left to the 11-6 judge or that examination is to be made by the arbitrator. Nobody is running away from the examination.
Mr. Banerjee,
Yes.
looking at the two stage that you are trying to point out, can we say that decision will have to be taken on shortfall or non-payment of stamp duty, but that is a deferred decision, and at the stage of 11-6, you don't have to take that decision.
Correct.
You defer it and relegate to competence of the arbitrator, whatever the...
I am
those
obliged.
principles
That
are.
is exactly my submission. And plus, to add to that, my lord, under 33 and 35, the arbitrator is an authority who is entitled to do that. It is not that one is running away. My lord. 33 says either appointed by law, maybe 11-6, or even by consent. So even supposing the matter had not come before an 11-6 judge, supposing we had directly referred it to the arbitrator, he would have to have a look at it under 33 and 35. And he would deal with the problem. He would be in a much better position, my lord, practically to deal with the problem also. He would take it.
Just wanted to put to you, you look at the scheme of section 11,
Section 11,
section 16,
16,
and also 8.
also
You
it.
can have 4 actually sort of contingencies which can possibly.
There are, yes,
One is an application is filed in the section 11.
11, my lord.
There is no contest.
No contest,
Actually, there is no contest.
right?
The matter is referred to the arbitrator. Before the arbitrator, a question is raised relating to the very existence of the agreement.
Right.
We'll come back to it as to
Yes.
whether it can be raised, number one. The second is 11. It is disputed by the party, but the court finds there is an agreement and refers to it. In that scenario, whether under section 16, whether it can be raised.
Second situation.
Second. The third scenario is under section 8, where he raises and the court says prima facie a valid agreement and therefore refers it. Now, whether there he can raise about the existence of the arbitration agreement. The fourth category is where without any application to section 11,
Nothing.
whether any dispute, the parties
Agree.
participate in the appointment of the arbitrator. Now, that is a case where neither 11 nor 8 party agrees and the arbitrator is appointed. Now, if you come to section 16(2), if you read section 16(1) to begin with once again for the purpose of clarity.
16(1), my lord,
Yes.
is that the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity.
That's right. Now you read subsection 2.
2 is a plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, party shall not be precluded from raising such a plea merely because he has appointed or participated in appointment. So merely
Therefore, even without recourse to section 11, there may be cases where parties the claims are referred to the arbitrator, they advise in it, they participate in it. That will not stand in the way of the person participating, provided it's before laying his defense, raising the contention about the jurisdiction. You will notice one aspect.
Jurisdiction.
In subsection 2 is
jurisdiction.
referred to as jurisdiction.
Jurisdiction.
Now, in subsection 1, it says jurisdiction including
Existence and validity.
existence or validity of.
It's a wider power.
So whether existence is the same as jurisdiction.
Existence is my lord, I would put it in concentric circles. Existence is the narrowest. Validity.
Therefore, the upshot is in these 4 categories which you have outlined. In a case, the first case where without 11(8), a party participates in the agreement,
No problem, my lord.
then can he come and say, not jurisdiction, but the existence of the agreement,
Yes, my lord, he
can he
can.
challenge it?
He can.
Which
He
is
can because of
which is a
16.
judgment- Which is a judgment which lays down that.
My lord, 16.1 says so, my lord, straight away. And my lord, Praveen Electrical says so. Praveen Electrical.
Section 16(1).
16.1, my lord, you are ruling on your jurisdiction, including questions of existence or validity.
That's right. Therefore,
What if,
what the question is whether the plea relating to the existence.
Existence, my lord, is specifically there in 16.1.
We know that. We are saying that whether existence of the agreement is a matter which goes to the jurisdiction of the arbitrator. You say that it is.
It does, its section says so, my lord.
Including is actually
Including.
the word including.
Including.
It means it's a part of jurisdiction.
Correct.
Correct. Now, then what happens if he participates in the section 11?
My lord, I have done a number of cases like that. You say without prejudice, I appoint Justice so and so as my arbitrator, and at the beginning you say there is no concluded contract.
Okay.
So there is no agreement. Please decide.
These are all covered by authority.
All covered. So that is, my lord, situation one. More problematic, my lord, is situation which my lord put to me. Supposing, my lord, I say there is no agreement. I refuse to participate in the appointment of arbitrator. The other side compels me to, the other side is compelled to take the assistance of section 11 to have an arbitrator appointed. In that proceeding, my lord, I say that there is no concluded agreement. It is forged, it is fabricated, there is no concluded agreement. What happens then? Because, my lord, 11.6 uses the word existence. My lord, this is far beyond stamping, my lord. We are on a very narrow. My lord, if I say there is no agreement, so what is the 11.6 court supposed to do in such a situation? My lord, that specific case is there in Praveen Electricals in your lordship's, my lord, compilation I have put it.
So even if he disputes and still 11 is allowed.
My lord, it is very interesting. There what the court says, my lord, and it takes recourse to Vidya Drolia and it takes recourse to the legislative history is, supposing you find that really there is no agreement, then you take a final view on that and throw it out. There is no agreement, there is no concluded contract. If you feel that it requires, if you, the 11 court feels that it requires a deeper consideration, that it is not clear, one party is saying it is forged, the other party saying it is not forged, then you leave it to the tribunal. So that is how this court, my lord, has both in Vidya Drolia and in Praveen sort of, my lord, harmonized 11.6a existence and 16 existence.
Supposing the court actually overrules the respondent's plea that the agreement is disputed for X, Y, Z reasons, goes into it at some length,
My lord,
and then finds, no, what you're saying is not correct. There is an agreement, and the vitiating factors you attributed to it or that it's afflicted with, it does not exist. Very concrete findings are rendered. Will it still be open to the arbitrator in section
my lord,
16 to reopen it?
that assumes, my lord, that the court will give concrete findings in 11. Now, my lord, that is exactly what happened in that case. The High Court gave very concrete findings that an agreement did exist. This court said, no, you should not have gone that far. You should have stopped at the point where you prima facie found an agreement to exist. And because ultimately, my lord, a final determination like that in an 11 jurisdiction then will require evidence. Because then one party will say it is forged, one party will say, I did not enter into the agreement. So, my lord, that is how it has been resolved. Your lordship will just see that. I'll show that judgment, my lord.
which?
Volume 2, my lord, page 136.
Which?
136, my lord, in the Arbitration Conciliation Act volume, my lord. Praveen Electricals versus Galaxy Infra. My lord, 2021 5 SCC 671. Now, this is exactly what had happened in this case. I'll read the head note and I'll not show the dispute and I'll show the finding. Dispute regarding existence of arbitration clause, reference of such dispute when warranted, prima facie reviews the referral stage, prima facie examination to weed out manifestly ex facie non-existence invalid agreements and non-arbitral. Inadequacy of where such prima facie review would be inconclusive, inadequate matter requires detailed consideration, cross-examination of witnesses. Such cases held issue of existence to be referred to the arbitrator for determination as a preliminary issue. So this is how, my lord, this bench resolved this sort of dispute. Now, my lord, in this matter, what had happened was that the single judge went into it in great detail, and the argument, my lord, at page 146, para 8, Sri Shyam Diwan argued that it was a concocted document. And, my lord, the reply is at page para 10. Then there's a discussion, my lord, of the Vidya Drolia, etc.
Para 16.
16, my lord. Vidya Drolia is discussed, 8 and 11 is discussed, existence is discussed in para 17, 18, 19, my lord, and then the final Justice Ramana's judgment is discussed, and the ratio of this judgment is 22 and 23 at page 167. And, my lord, the facts are dealt with in para 29, where Justice Nariman says facts of this case remind us of Alice in Wonderland. And he says that this is a matter which requires investigation, and he then sends it to the arbitrator. And the judgment of the High Court is set aside insofar as it conclusively finds that there's an arbitration. That is set aside at paragraph 30. So the High Court found that there was an agreement. This court said, no, you should not, you should stay your hands. If you find that there is prima facie, there is an agreement, please, unless it is obvious that there is no agreement, supposing, my lord, even in institutions, supposing there is a clause which says LCIA and your institution is MCIA, then the institution will reject. Or supposing there is actually no correspondence between the parties, and it is obvious, then you don't interfere in 11. But, my lord, the question, so this is so far as existence is concerned. But, my lord, fortunately for us, in this matter, we are not on existence per se, but this is the place where we are.
In some cases, not the big contract, what's happening is the arbitration is surfacing post-contract.
Yes.
After agreement is executed, a voucher is given,
Yes.
on it is written there's an arbitration clause. So that possibly doesn't come within the scope of this reference. But there also the question as to whether that arbitration clause is valid or not might come. Because there was no contract
But it happens so often.
between the
It
parties.
happens so often, my lord. We go to the park a car in a hotel. They give you a voucher. It has an arbitration
Yes.
clause. It happens. It happens. My lord, there, unless, my lord, there also, my lord, I would go to the stage of saying that this judgment gives you the answer. You please direct an arbitrator. You decide as a preliminary issue whether at all an arbitration agreement exists. Please give full play to 16. Moment there is some detailed adjudicatory function which is happening, my lord, either the clause is patently void. There are some judgments, my lord. There are some commentaries referred to in Justice Thakkar's book that unless you can see on ex facie, my lord, the text is which is there also in Vidya Drolia, unless it is, my lord, it is manifestly an ex facie non-existent. If you see it and you say this is just, I mean, I will not refer it. For instance, there's an arbitration clause and it is from proceeds of crime. Or there's an arbitration clause where the Rent Act applies and both parties say, yes, the Rent Act applies. So then don't do it. But not extreme cases always make bad law. So, my lord, 11 has to be given with respect, my lord, a narrow meaning.
And only good law services also from extreme cases.
Good law, my lord, also maybe, my lord.
One thing, so See, what is the basis for the submission that the scope of 11.6a is only to look into the question whether prima facie. Now, why the court is approached for appointment of an arbitrator? And then, see here, suppose the power is the section is also, it clearly says the court may.
May.
So if the court finds that, of course, dispute is there, we need not consider it finally a prima facie.
Yes.
But the court, suppose, finds that here, now the court can take a final decision. And if it takes a final decision, now whether can you say that no, the power is very restricted and you cannot take a final decision?
I'm not saying that.
And then the arbitrator shall again look into that.
What is the final decision the court will take? My lord,
So therefore, see, going by this section, there is nothing which indicates that the power is very restricted.
my lord,
Because, see, the court is supposed to, going by the words, confine. So even after confining the examination on one question, whether this arbitration agreement is in existence or not, even after consigning the full consideration on that question alone, you are saying that that is only for the purpose of entering into a prima
my
facie.
lord, I will put it a little differently. Your lordship is right. It does not say it. Your lordship is right. In fact, to be fair, my lord, even in this three-judge bench, it is clarified that this was by a process of judicial interpretation. That is clarified, my lord.
It is just like see, suppose when the alternative remedy is there, the court need not exercise or invoke the power. But once it exercises it, can anybody sit over that? So here, court may, but once the court decides, yes, we will consider it and confining our consideration into the question of existence of arbitration agreement, and then enters into a final conclusion on that. How can, just because 16A also permits that, how can the arbitrator again look into that
My
question?
lord, there may be two outcomes, my lord. One is the court finally decides there is no agreement. Then the matter is over, my lord. Matter is over. That's a
Definitely.
final decision.
Definitely.
There has to be, so my lord, if the case comes, so if there is a final decision that there is no arbitration agreement, my lord, then there is no appointment. Matter ends, my lord. So to that extent, there is a final decision. My lord, there is some interesting commentary on this issue which your lordship has raised, my lord, on final and prima
And on
facie.
the other question.
On the other question.
And if the court, after considering it, after considering the agreement, finds that there is an arbitration agreement,
So, my lord,
how that conclusion of the court can be interfered with
right. Now, my
in
lord,
exercise of power under 60.
in exercise of power under 16. Now, my lord, this was in fact the exact debate in SBP. This is exactly, my lord, the debate in SBP. My lord, to answer that question, yes, certainly, my lord, 11.6a can be read in that fashion. It can be read in that fashion. But as my lord said, my lord, as a matter of prudence, there are two options open to an 11.6 court, my lord. One is that I will finally decide.
Therefore, my question is it not for the court to decide? Taking into account the nature of the question, yes, it needs taking into evidence or consideration of evidence, etc. Party should be let in, permitted to
Then
let
let
in
it.
evidence.
Then go.
Then, of course. But if the court thinks that no, this is a matter where conclusion could be
Easily.
finally,
Easily.
then how can?
No, I agree, my lord, that this judgment does not go so far to say that it is, my lord, cannot be done. Again, my lord, fortunately or unfortunately, my lord, we are not on this aspect, but your lordship is right. If the court feels that it can finally decide
I
it,
put that question because at the outset itself you said the scope of 11.6a is that the court should confine the consideration only
Right.
in the question of
right?
existence or otherwise of arbitration agreement.
Yes, my lord. So far, so good.
And again you said that now 16, that should be prima facie conclusion. And then 16, where evidence can be, this can be permitted to let in evidence, and therefore the real consideration regarding the existence should be under 16. Whether to what extent that can be accepted.
My lord, I am only just placing, my lord, this particular green electrical judgment. Of course, it is 3 judges for your consideration, my lord. As my lord said, it is really a matter of prudence. It is not supposing, my lord, a 11 court comes to a final conclusion that X agreement does not exist.
Because that's a 3-judge judgment and we are sitting
Absolutely.
Therefore, we have to put all those
Yes,
questions.
absolutely. My lord, I'm conscious of that. I'm only presenting, my lord, this is the view and the logic appears to be brought. I'm not saying that in an appropriate case, the 11 court cannot finally determine.
That is why may. That
May.
discretion is with the court.
Right. My lord,
May.
may. So, my lord, the question is, in exercise of that discretion, how would the court act if it can easily be decided? As the 3-judge says, it can easily be decided, it is manifestly and ex facie non-existent. Then the court will decide.
Legislative intention is not actually reflected from this, saying that the court is only supposed to take only a prima facie conclusion. There is no such legislative intention is indicated in or reflected in.
In this section, my lord, I just show the history and the intention, and my lord, on the basis on which this view has been taken. My lord, your lordship is right. It will fit in the word may. How do you understand may? When you are you meaning, my lord, the 11 court is exercising the discretion. How will that discretion be exercised? The discretion will be exercised in the fashion that when you want to cut out the dead wood, not the Vidyadrolya view, when you are clear, when it is obvious, when it is something that can easily be decided, court can decide it and close the matter. No difficulty, my lord. But how to exercise that discretion, your lordships may consider, my lord. In that situation, when you need to take evidence, when you need to go into a deeper consideration, maybe you should not exercise the discretion.
One more reason is there. You yourself admitted the fact that the court is having the exclusive jurisdiction to decide whether such an arbitration agreement exists or not. And it can also say no such arbitration agreement exists. Then that would be the end of the matter.
And no is
If
no.
so, the court should also have the discretion, the power to say that yes, there exists.
My lord, if that power is exercised, my lord, and that will also have to be, my lord, read with 16. So 16 will also have to be given some meaning.
Harmonious construction.
Yes, my lords, what way it was resolved is that you went back to the old law and said with intervention of court there is a different result, without intervention of court that's a different result. But 16 does not seem to make that distinction. And my lord, again, then we go back to the question of whether it's a judicial function or administrative function and it's not a court like, my lord, your lordships are sitting as a court. 11-6 court is not really such a court. My lord, that's what I wanted to, my lord, emphasize. It is not this court, my lord. It is not a constitutional court which is deciding matters of law, my lord.
But why was there was a change of judicial view about this being an administrative function to a judicial function? 11.6. Is 11.6 a judicial function or not?
My lord, my lord, please do not go into this judicial or administrative function. It has all sorts of, I will argue, my lord, it is an administrative function and therefore, my lord, the entire basis of 11.6a was removed. Please approach the question in a different way. As my lord says, my lord, there are 2 questions. The 2 questions are referred to in para 28 of the Law Commission report. 2 questions, my lord. I just want to show the Law Commission report.
Without one more thing. See, just with regard to power. The second proviso to 3A.
3A.
It says Chief Justice of the concerned time. So it is Chief Justice. But 6A, Supreme Court or the High Court.
My lord, the reason.
It's not Chief Justice.
It's not Chief Justice. The reason for that amendment, my lord, is explained in the Law Commission report. The reason for that amendment was not to give it court powers, but
the question is, and then see wherever the second proviso it only says Chief Justice of the High Court, but when 3A consciously the wording is the High Court or the Supreme Court.
Correct.
Then how can you say that it is only an administrative?
My lord, again, I don't want to go into the administrative.
We are only
My lord, the reason, I will also explain to your lordships, my lord, what was the reason for introducing the word court? That is reflected from, my lord, the Law Commission. It was not meant to change the character from and accept that it is judicial. My lord, the reason for it introducing the word court was only because, my lord, otherwise there would be some difficulties in the nature of the appointment.
One more reason is there. You yourself very specifically admitted the position that once exercising the power under 11.6a, the court arrives at a finding that there exists no arbitration agreement, then that would be the end of the matter.
That's the end of the matter.
It is in exercise of the same power, the court is now arriving at a different conclusion. No, there exists.
My lord,
How can you say that when it enters into the decision non-existence,
my lord,
then it is final?
in non-existence, my lord, it happens all the time, my lord. Even in institutions, my lord, it does not change the color from administrative to judicial. In many cases, non-existence of arbitral, you go to an institution, you say, I want to go for arbitration. The institution says it does not exist. That's the end of the matter, my lord. Then you go to suit. That does not necessarily mean, and that's a final decision. The SEAC tells you that, I'm sorry, this arbitration agreement does not exist. That does not necessarily, my lord, make it judicial. My lord, moment we go down judicial, administrative, court institution, my lord, we get into problems. So, and in fact, my lord, on this aspect, there was a lot of debate in section 8 and section 45. Justice Sabharwal took one view, Justice Sri Krishna took one view on this prima facie and finality. I'll show that, my lord, because
On 11.6 itself, view of the court had undergone
some change here and there.
yes.
So, my lord, to take away that, to come to a conclusion where this aspect, my lord, is limited, all these aspects, my lord, were looked at when bringing in 11.6. The my lord, question as to existence, my lord, may I, my lord, place the Law Commission report? It may address some of your lordship's concerns before I go to 16. Or would I, my lord, can I place 16 and then come back to
You
that?
proceed in your own way.
If I can place 16, my lord,
And
34, and then straight away Law Commission report, to understand, my lord, where this debate is going. My lord, I'll just complete 16 and 34 and come back to the Law Commission report. And some of these questions which have now been raised, my lord, your lordship will see the discussion as to how it is there.
these questions are being raised as corollary to the issue we are.
Testing, my lord, the scope. Your lordship is testing the scope of 11.6.
Yes.
And that is a question which does fall for your lordship's consideration in some fashion. Lord, 16 is the competence of arbitral tribunal to rule on its jurisdiction. Arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And for that purpose, A, an arbitration clause which form part of a contract shall be treated as an agreement independent of the other terms. So this is, my lord, one, because normally a jurisdictional, a tribunal of limited jurisdiction cannot decide its own jurisdiction. This is the reversal of that policy statutorily. A decision by the arbitral tribunal, contract is null and void, shall not entail ipso jure invalidity of arbitration clause, and plea does not, that your lordships have already seen. And then, my lord, 4, 5, and 6 is how the party proceeds. And 6 is a party aggrieved by such arbitral tribunal may make an application for setting aside an arbitral award in accordance with 34. So 16 remedy is under our law only pushed back to 34. But, my lord, I just want to show the contrast. Thank you.
This preliminary determination in 16 will have to be challenged in
34. My lord, I just want to show why we are having this 11 jurisprudence. This provision which I am showing to my lords has been, my lord, advertently or inadvertently left out by our legislature. We have been, my lord, more loyal than the king.
We can't presume Inadvertently left out.
or
by
advertently,
the
my lord, or
legislator.
inadvertently, it is caused, my lord, absolute chaos.
Has to be we proceed on the basis that legislature was conscious of what
In
it
96, my lord, of this, my lord. In fact, it came through in ordinance. My lord, this is the extract from the UNCITRAL website, which shows the model law. And here your lordships will see 16.1, which is very, very similar to what we have. 16.2 is also very, very similar to what we have. But 16.3 is something that is missing. Arbitral tribunal may rule on a plea referred to in paragraph 2 of this article either as a preliminary question or an award on the merits. If the arbitral tribunal rules as a preliminary question, it has jurisdiction. Any party may request within 30 days after having received notice of that ruling, court specified in Article 6 to decide the matter. So, my lord, in the UNCITRAL model law, what happens on the existence issue is that it is not really decided in 11, it is decided at the 16th stage, and the court has always has the final word. So whatever the arbitrator decides, the court has the final word. Court can conclusively hold that there is no agreement. But this is the stage at which is normally it is done. Your lordship, just see the commentary. Introduction. Article 16 addresses three issues that may arise when the parties disagree as to whether their dispute ought to be resolved in arbitral or judicial proceedings. One is the separability principle. This is what NN Global, my lord, highlights, pursuant to which an arbitration clause forming part of a contract is to be treated as an independent or separate contract, separability. Another issue is the arbitral tribunal's power to make a determination as to its own jurisdiction to deal with the substantive claim in dispute known as principle of competence, affirmed and so on. So finally, 16.3 addresses the court's power to review as a preliminary phase, which unfortunately is missing in our, my lord, act. And had this possibly been there, we would have had very little jurisprudence on section 11, whether judicial, administrative, scope, level of inquiry. All this would have been gone to the 16th stage, where the court would have had a look at evidence, at the arbitrator's preliminary determination. Everything would have been dealt with at 16th stage. And at that stage, the court would have had full jurisdiction to look at everything, knock out bad agreements, continue with good agreements, existence, validity, stamping, everything would have been done. But this is unfortunately missing in our statute. My lord, this is 16. One more paragraph I want to show in 16, my lord. In respect of 16. And my lord, the importance of 16. Please see the 7-judge bench. 2005, 8 Supreme Court cases, 618. This unfortunately, my lord, I didn't file this because it's a very bulky judgment. So the request your lordship look at the book.
On what point you are?
My lord, just the scope of 16.
2015, 8 Supreme
2005, 8 Supreme Court cases, 618, SPP and Co. versus Patel HM. On this portion, there is no inconsistency between majority and minority. Not page 678, Justice Thakkar's dissent. Please see 2 paragraphs only. 90. My lord, may also note para 87 just as by way of approach, where the international practice is recorded. The Law Commission, the international practice 87 para 87. Lordship will note that paragraph on the approach. But please now see para 95 and 96. 87 says court should only verify clause is not patently void. That this seems to be the general trend. Now 95. Now let us consider section 16 of the Act. Section is new and did not find place in the old Act of 1940. 1940, it was the court who would ultimately decide jurisdiction. This is the bottom of page 678. then, my lord, subsection 1 is analyzed, 2, 3, and 4 are analyzed, and my lord, top of page 679, subsection 5 mandates the arbitral tribunal shall decide such plea where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding, make an arbitral award. Emphasis applied. Section 6 is equally important, expressly enacts that a party aggrieved by an arbitral award may invoke 34 for setting aside. The provision appears to be made to prevent dilatory tactics and abuse the immediate right to approach the court. If an aggrieved party has the right to move the court, not have been possible to preclude the court from granting any stay or interim relief which would bring the arbitration proceedings to a grinding halt. Provisions of 16(6) read with 5 now make this legal position clear, ambiguous, and free from doubt. Then, my lord, 96. Section 16(1) incorporates the well-known doctrine of competence de la competence, recognizes and enshrines important principle that initially and primarily it is for the arbitral tribunal itself to determine whether it has jurisdiction in the matter, subject, of course, to ultimate court control. It is thus a rule of chronological priority. Competence, widely accepted feature of modern international arbitration, allows the arbitrator to decide its own jurisdiction, including ruling on objection with respect to existence of validity, subject to final review by a competent court. So, my lord, the policy of 16 is first bite of the cherry with the arbitrator, second bite of the cherry, and the conclusive one, second call, is with the court. The court will ultimately decide all these questions at an appropriate stage. And, my lord, there are various commentaries which he has put in after that. The learned judge has put in, has also referred to Renu Sagar, my lord, on this. So, my lord, this paragraph just shows, my lord, what is the purport of 16. So, the submission, therefore, is, my lord, that certainly 11 has its own play, but 16 is also there, my lord. It is not made subject to 11.
This is the concurring view or dissenting?
This is the dissenting view, my lord.
Maybe
But on
paragraph 12 of that letter, which sets
12.
out the majority view.
12, my lord, I'll leave it.
The view of Justice Balasubramanian,
Balasam.
speaking on behalf of the bench.
Right. Section 16 of the Act only makes explicit what is even otherwise implicit, namely that the arbitral tribunal constituted under the Act has a jurisdiction to rule on its own jurisdiction, including ruling on objections with respect to existence or validity of the agreement. Subsection 1 also directs arbitration clause which forms part of a contract shall be treated as agreement independent of other terms of the contract. Also clarifies decision by arbitral tribunal the contract is null and void shall not entail ipso jure invalidity of arbitration. Subsection 2 enjoins that a party wanting to raise a plea that the arbitration tribunal does not have jurisdiction has to raise that objection not later than submission of statement of result, and that the party shall not be precluded from raising.
Come to perhaps the next page,
Next
towards
page.
the middle,
Yeah.
say after B, the question in the context
Is what is the scope of the right conferred on the arbitral tribunal to rule on its own jurisdiction and the existence of arbitration clause envisaged by 16(1) once the Chief Justice or the person designated by him had appointed an arbitrator after satisfying himself conditions of exercise. Prima facie, it would be difficult to say, in spite of the finality conferred by 11, such a decision, Chief Justice, Arbitral Tribunal can go behind the decision, rule on its own jurisdiction on the existence of arbitration.
This is the view.
This was the view taken, my lord,
This has
but
been legislatively overruled.
this was legislatively, my lord, overruled.
Now, if you come to how Dodia deals with this, please come to paragraph 138 of Dodia.
Of Drolia.
And then particularly at page 140. The actual procedure to be adopted is laid down there. You can read paragraph 138.
Lord, in fact, this discussion of prima facie view starts at 134 also.
We can start with 138 because actually, it splits up into 3 categories.
My lord, there is a problem with Bokhara.
Ah.
Because Bokhara has been curtailed, my lord, legislatively, specifically, and there are some comments in Justice Ramanna's judgment which say that even the Bokhara view is not the view today. My lord.
That's right. But if you come to page 139 and 140 to be more specific.
139.
Paragraph 139, 140, page 147.
My lord, this is, we would not like to be too prescriptive. This is page 147 of the compilation.
So you can read that.
Of the, my lord, the first volume. This, of course, was in the context of arbitrability and subject matter arbitrability.
But you
Specifically,
just see, if you read it, you'll see.
we would not like to be too prescriptive, albeit observe that the court may, for legitimate reasons to prevent wastage of public and private resources, can exercise judicial discretion, may to conduct an intense yet summary prima facie review while remaining conscious that it is to assist the arbitration procedure and not usurp jurisdiction of the arbitral tribunal. Undertaking a detailed full review or a long drawn review on the referral stage would obstruct and cause delay, undermining the integrity and efficacy of arbitration as a dispute resolution mechanism. Conversely, if the court becomes too reluctant to intervene, it may undermine effectiveness of both the arbitration and the court. There are certain cases where the prima facie examination may require a deeper consideration. The court's challenge is to find the right amount and the context when it would examine the prima facie case or exercise restraint. The legal order needs a right balance between avoiding arbitration, obstructing tactics at referral stage, and protecting parties from being forced to arbitrate when the matter is not clearly not arbitrable. Accordingly, when it appears prima facie review would be inconclusive or on consideration inadequate as it requires detailed examination of the case which I cited, Praveen, the matter should be left for final determination by the arbitral tribunal selected by the parties by consent. Underlying rationale being not to delay or defer and to discourage parties from using referral proceeding as a ruse to delay and obstruct. Such cases, a full review by the court at the stage would encroach on the jurisdiction of the arbitral tribunal, violate the legislative scheme, allocating jurisdiction between the courts and arbitral tribunal. Centralization of litigation with the arbitral tribunal as the primary and first adjudicator is beneficent as it helps in quicker and efficient resolution of disputes. Then, my lord, court would exercise.
144, now you may read. And a 140.
As observed earlier, Patel Engineering explains hold that section 8 and 11 complementary in nature, both relate to reference. Section 8 applies when the judicial proceeding pending, application filed for stay of judicial proceeding, reference after. Amendments to 8 have not been omitted. Section 11 covers the situation parties approach. Mayawati Trading, in our humble opinion, rightly holds that Patel Engineering has been legislatively approved and hence would not apply even post omission of 6A as to section 11 of the Act. Mayawati Trading has elaborated on the objects and purpose and history of the amendment to section 11 with reference to 6A to elucidate the section as originally enacted, facsimile with article 11 of Law of Arbitration, which the Arbitration Act, referring to the legislative scheme, section 11, different interpretation law commission, it has been held omitted 6A would continue to apply and guide the courts on its scope of jurisdiction at stage 1 pre-arbitration stage. So, my lord, this is the.
Therefore, what you are trying to put to you is from Patel Engineering, paragraph 12, we pointed out majority takes the view. The court in 11.7 holds that there is an arbitration agreement exists.
Then it's over.
Then it should be over in terms of the majority. Not open to the arbitrator to rake it up in, the parties
at all.
Rake it up, number one. Now, SPB, that majority has been overruled.
Registered.
And the text is changed because of the introduction of 6.
Correct.
Now, interpreting this Dolia and the earlier judgment appears to be one way of doing it.
Yes, ma'am.
That the High Court or perhaps the court under section 8, when it refers in a case which is a little nebulous,
right,
where, prima facie there is an agreement, exists an agreement. But the court does not want to really finally hold there is an agreement.
It can then.
Device can be to actually expressly make it clear that we are doing it in this way. You will not take away your right
Under 16.
Agitated under section 16.
Correct.
One that might perhaps hold a key
to
solving this problem as to in which case the parties are yet free despite a finding.
Yes, madam.
Or the second thing is the court should not go elaborately into it.
Correct.
You begin with that.
Right. Or if it is obviously but not manifestly, if the court feels that this can be closed quickly, then the court can close it.
Matter is over.
So, Balod, it is really as.
So it really depends on what the court will really get to say.
Right.
First of all, understanding the limited nature of its jurisdictions at that stage.
Balod, the practical situation is this: your lordships are a court. The High Court is a court. Courts want to decide.
That's it.
That's the normal.
So when
That's the normal, my lord. It's very difficult for the court to say
what the court can do is
to step back.
the court say, prima facie, step one, there is an agreement. It is in writing. It discloses that there is an arbitration agreement. Okay. X, Y, Z factors are urged against its validity, even against its existence.
Even
The
existed.
court finds that these are matters which are better gone into in a section 16.
Correct.
So there the court says there is an agreement. We leave it open to you to take all your contingency in section 16.
The Alice in Wonderland case, my lord.
The real solution is this court may make it clear. that
Court
you are
will
not
make it clear.
Foreclosing your right under section 16. The matter will
In
be
fact,
over
my lord,
quickly.
your lordship, that clarification has to be given, my lord. In fact, in Praveen Electricals, that was specifically made
Once
clear.
you do that, the end of the matter. You don't have to sit in for years together, like 11 years in Jammu and Kashmir, where you spoke about. I mean, it can be avoided if you have this.
My lord, it is basically something which is against the nature of the judge. The judge is there to decide issues. But here, my lord, the judge has to step back and leave it to somebody else. It goes against the judicial, my lord,
It's a change in law. Actually.
nature.
The legislature has
The legislature
the
wants-
text of the act, and therefore SBP has been overruled. We have to accept that unless we hold
have
that
to accept
the
that.
judgment is wrong.
We have
Therefore,
to.
para 12, which appears to suggest that if once a court enters a finding regarding even the existence, there is a bar under section 16. That may not continue to hold good, but the care must be taken both in the exercise of jurisdiction under section 11, 8, and also making it clear appropriately in the order.
Lordships will clarify.
If that is done,
There should be no problem.
clarify the whole thing.
There should be no, my lord, that actually happens in cases where it doesn't go to court. It happens, my lord. You appoint subject to this, and then you go ahead.
Go ahead.
And you first preliminary point you raise, it is void, it is contrary to competition law, it is, etc., etc.
As they would say that the cause of arbitration will be served even by those who stand and wait, not necessarily that by not adjudicating, you are doing injustice.
Yes, my lord. In fact, this is a case where the court need not
Step back
should. My lord, it's difficult. It is difficult because
by tendency.
tendency, and my lord, if your lordship sees some injustice, then it is very difficult to tell a court, now you don't look at it, my lord, please send it to the arbitrator. That is something which is, as my Lord Justice Bose said, the case of the piece of paper with the arbitration clause. The court wants to step in. So, my lord, there, of course, there's a Consumer Protection Act.
Praveen was a case where they found that there's no existence. Yet Supreme Court did not disturb because there are a lot of evidence.
A lot of evidence
into account.
It was a concocted agreement. It seems like
That Alice in Wonderland analogy came in only because of the situation prevailing there.
That's right.
It was not in existence.
Not in existence.
I have forgotten how to speak English.
That's right.
See, if you do online transaction, the offer and acceptance is complete, then the goods arrive, and in that product description or something, there is inserted an arbitration clause.
Yes,
That is post-contract.
post-contract. Well, no, there, of course, there is another point. That's a consumer
Yeah,
dispute.
we don't want to engage in that, but
There, well, not then that it may not be arbitrable at all because it may be a consumer dispute. There are
somebody may like to go to a suit court also.
somebody may like to go to a suit.
Then that section 8 question.
Section 8 question will come.
But we must not get derailed too much because here we are on a stamp.
We are on a very limited.
So therefore, otherwise
Otherwise, this discussion will continue. Well, not, let me then, just place 34 and 41. SOR. Don't place SOR.
One more thing, see, at the time, the decision in SPB was rendered.
Correct.
The position of 7-6 was different.
6 was different.
It was totally different.
Totally. Well, not in fact, therefore 6 was interpreted in that particular way.
And again, then section 7 was also there. I mean, subsection 7.
7 is still there.
But then
7 is still there. Unfortunately, it's there. 7 is still there.
By the present ones, after 6B, it is 8.
No, that may be the 2019 it has been delayed. 19 it has been delayed.
7 also 16.
7 has gone in 19. It is still there.
Up to 9. That is Act 33 of 29.
That has not been notified, that portion.
That is also.
That's
Just like.
so, it is unclear what the law is. Some portion is deleted, some portion is not notified. There is a very nice chart.
In SBB, section 7 was also taken into consideration.
Yes, yes,
But section 6 at that point of time, it was totally.
totally.
But still in paragraph 15 of SVB, there is a finding that that decision is judicial, in excess of judicial power.
Yes, Manoj. That's where the
It's not administrative.
it's
Paragraph 15 very categorically held that it is judicial in exercise of a judicial power.
Malord, I just want
Paragraph 15.
right. Malord, may I just now show Malord? Yeah, we've shown section 16, Malord. The Lordship will just see 2 more sections, and I'll just show the comment. The Malord, the law commission. At 4 and 45. My lord, just see before the law commission. Please see. I just complete the act, my lord, and then come to the law commission, which will perhaps assuage some of these issues. My lords have seen 16. Just complete it. Please come to 34 for me. Yes, yes. Ayavati also.
Followed by in
Praveen.
Praveen and
Three judges. By Vidya Jolia. That seems to
that appears to sort of crystallize the law, apart from overruling. It said of the limited nature is stated level.
right. Yes,
See
yes.
whether it exists. That's it.
My lord, Vidya Jolia, little bit of fine tuning, little bit may
A
happen.
little bit.
It may happen.
You're right.
My lord, just see 34. 34 is a provision, my lord, which is effectively a copy of the model law. And the reason I am showing 34 is, my lord, 34 has 2 limbs. 34, my lord, 2A and 34 2B. 34 2A is a defense raised by a party. 34 2B is something that the court can find by itself. There is a distinction, my lord, normally people do not notice. Then your lordships will note that 34A has 5 different subheads. Your lordships have 34 2A. Arbitral award may be set aside by the court only if the party making the application established also one party is under incapacity, etc., etc. There are 5 subheads of 34 2A.
2019 5 and 6 years.
34 2A has 5 subheads and 34 2B effectively has 2 subheads. Well, each of them are different, and there is a reason I am raising this, my lord, because it has some relevance to Vidya Jolia also. My lord, may just see 34 2A 2. 2A2 says the arbitration agreement is not valid. So it is invalid under our law. That is one situation where the agreement itself is invalid. Validity may possibly also include existence. Then, my lord, please contrast it with Roman 4. The arbitral award deals with a dispute not contemplated within the terms of submission or contains matters beyond the scope. My lord, this is little different. 2 is validity of the clause. 4 is a dispute which does not fall within a clause. My lord, this may be relevant for Vidya Jolia. Then, my lord, a different heading is now 2B1. 2B1 is the subject matter of the dispute is not capable of settled by arbitration. So there is subject matter arbitrability. This is the issue, my lord, which was raised in Jolia. Namely, that even if there is an arbitration clause on the face of it, but in fact it is barred by landlord tenant. And then, my lord, the next heading is public policy. So public policy is treated differently. Dispute not capable of arbitration is a matter only for the court to decide, because the court will ultimately, even if there is an award, even if nobody raises it, court will decide. So, my lord, this is 34. Your lordship will just note this. And, my lord, 45. The relevance of this, my lord, I'll come to later. But 45. 37. Conditional appeal. We'll leave it. 37 to 37 is the appeal provision, which shows only there's a conditional appeal in 16. And then, my lord, 45 is in part 2. My lord, I am only, this is actually under the New York Convention. We are stricto sensu not concerned with. But it uses the expression unless it prima facie finds that the said agreement is null and void, inoperative, or incapable of being performed. So, my lord, if your lordship steps back and now looks at the Arbitration Act in entirety, Section 8 uses the word validity. Section 11 uses the word existence. Section 16 uses the words existence, validity, jurisdiction. Section 45 uses the word null and void, which means validity, inoperative, incapable of being performed. In different sections of the same act, very different phrases are used.
Have you given this
I've given
description in your note?
I've given the description at page. My lord, we will have to give some meaning to the text also. So where existence is used, please use existence. Where existence or validity is there, please. So, my lord, after all, the legislative, my lord, intent is reflected best from the language. So, my lord, this is so far as the act is concerned. Now, my lord, the most important amendment came in 2015. And again, my lord, we are going away slightly from stamping, but it has some relevance. Please now see the Law Commission report, which has been now, my lord, referred to in n number of judgments. There are 6 or 7 paragraphs. I would request your lordships to have a look at that. My lord, this is in Roman part 4, put it in the 4th word. This we can leave. I have given references to the statement of objects and reasons of each of the acts, 96 Act, 2015 Act, 2019 Act, what are the relevant? I'm not going into it, it's there in the note. I'm curtailing this. The lordship will straight away come to the 246 Law Commission. And please note, my lord, in this volume, pages 22 to 27, 49 to 51, and 52 to 55.
Volume.
Good.
No. Just
Both.
repeat these pages once.
22 to 27, the main discussion, 49 to 51, and 52 to 55. Because this is the legislative background to the bringing into existence of 11. My Lord Justice Rastogi has got this volume.
Yeah, volume 4.
Volume 4. My Lord, it's the report starts on page 1, and the relevant pages are 22 to 27, which are the main pages. My Lord, 22 starts. I'll just read a few portions, my Lord, just to put this in perspective. Delays in court before the arbitral tribunal investment treaty race. My Lord, this refers to that White Australia case. Judicial intervention in arbitration proceeding adds significantly to the delays in the arbitral process and ultimately negates the basis of arbitration. Two reasons can be attributed. First, the system is overburdened with work, not sufficiently efficient, dispose cases, especially commercial cases, speed and dispatch. My lord, this is really a reason which is beyond my lord, us at the moment. Secondly, the bar for judicial intervention, despite the existence of Section 5, consistently been set at a low threshold by Indian judiciary, translates into many more admissions cases in court arise out of related acts. So, my lord, 22 identifies two problems. 23, your lordships will skip, which is the wider problem. My lord, we are not concerned with this at this stage. 24, two further sets of amendments proposed. First, it is observed a lot of time is spent for appointment of arbitrators, very threshold of arbitration proceedings. Applications under 11 kept pending for many years. In this context, Commission has proposed a few amendments. Commission has proposed changing the existing scheme of the power appointment being vested in the Chief Justice of the High Court and the Supreme Court, and has expressly clarified that delegation of power appointment as opposed to finding regarding existence nullity shall not be regarded as a judicial act. This will rationalize law and provide greater incentive to the High Court to delegate the power appointment to specialized. So, my lord, this is one recommendation. 11.7 recommendation, my lord, is also there. Then your lordships will come straight away. So, this is by way of background. My lord, the main paragraphs are 28 to 33. These are, my lord, extracted in Mayavati also. But there is one paragraph, according to me, my lord, 29 is the critical paragraph which will address large number of issues. May I read 28? The Act recognizes situations the intervention of court is envisaged at pre-arbitral stage prior to the constitution of the tribunal, includes section 8, 9, 11 case of part 1, section 45 in case of part 2.
Which one you are reading?
My lord, para 28 at page 20.
Yes.
Yes. So, my lord, it recognizes situations the intervention of court is envisaged at pre-arbitral stage. Sections 8, 45 and also section 11 relating to reference to arbitration appointment directly affect the constitution of the tribunal functioning the arbitral proceeding. Therefore, their operation has a direct and significant impact on conduct of arbitration. Section 9, solely for the purpose of securing interim relief, although having potential to affect the rights, does not affect the conduct of arbitration in the same way. It is in this context, Commission has examined deliberated work. Now, my lord, 29. I rely on 29 as an understanding, my lord, of all the provisions. The Supreme Court has had occasion to deliberate upon the scope and nature, italicized, of permissible pre-judicial intervention, especially in the context of section 11. Unfortunately, however, the question before the Supreme Court, framed in terms of whether such power is a judicial administrative power, which obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e. the scope of arguments which a court / Chief Justice will consider while deciding whether or not to appoint an arbitrator, i.e. whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and which of these it should leave for decision of the tribunal. So, my lord, first, scope. What is the scope of 11.6? Second, my lord, what was put to me by my lord, Justice Ravi Kumar, nature of such intervention. Would the court consider the issue on a detailed trial, whether the same should be decided finally or left for determination? So, my lord, these are conceptually two issues that your lordships will have to decide on 11. What is the scope, which is what we are actually concerned with. We are not concerned with, my lord, the second portion of nature of intervention. What is
32 and 33 you have read? Look,
30, no, I have read only 30, then 32 and 33.
Please read that one. 32,
I'm reading that one. I have only come to 29, my lord. Then after a series of cases, Supreme Court held that the judicial power underlying issues were clarified by Bogara. So, my lord, then 30 Bogara set out. Commission is of the view that in this context, same test regarding scope and nature as applicable in context 11 should also apply 8 and 45, since the scope and nature judicial should not change depending on party intending to defeat arbitration agreement, refuses to appoint an arbitrator, terms of the arbitration, moves the proceeding before judicial authority. In relation, my lord, this is to answer the question which fell from the tribunal. In relation to the nature of the intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu versus Aksh Optify, my lord, 2-1 judgment in the context of 45, where the Supreme Court has ruled in favor of looking at the issue controversy only prima facie. Justice Sabharwal took a view, Justice Sri Krishna took a view, and there was a split verdict. It is in this context, Commission has recommended amendments to the Section 8 and 11 of the Conciliation Act. Scope of judicial intervention is only restricted to the situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Even this was not accepted by the legislature. Even this was not accepted. The legislature cut out null and void. It went one step further and said existence. But I actually, my lord, personally, my submission is that there is really not much difference between existence and validity. It may be that the word existence may also in some way cover validity. It is not merely that your lordships will see on a piece of paper an agreement is there. Maybe some inquiry will have to be there. Is there some consideration? Is there something will have to be said? So, my lord, the recommendation was exist, null and void. Inoperative, incapable of being performed, not included. So, existence and null and void. Similarly, my lord, insofar as nature of intervention is concerned, recommended in event court is prima facie satisfied against the argument challenging the arbitration. It shall appoint the arbitrator, refer the parties to arbitration. Amendment envisages the judicial authority shall not refer only if it finds that it does not exist in arbitration agreement or it is null and void. If the judicial authority or the opinion prima facie arbitration agreement exists, shall refer the disputes, leave the existence to be finally determined. However, the judicial authority concludes the agreement does not exist, conclusion will be final. So, my lord, this was the understanding in Shinetsu and this is how it was. And, my lord, the amendments which were suggested are there. So, this is, my lord, the critical part of the report is paragraph 28 to 33.
Para 10 also, para 10 of we are reading Mayavati actually.
Oh, your lordship is reading Mayavati.
So,
I am reading it from the report, my lord, because
it is incorporated in the.
my lord, para 8 to 14 of Mayavati actually summarizes it. But interestingly, my lord, one or two of these paragraphs are not mentioned in Brolia. So therefore, my lord, I read it from the.
Therefore, the trick lies really in the manner in which both you approach it and how you couch the order.
How you couch the order.
If you say that there are contentious issues, we are not fully satisfied, but there is prima facie an agreement, say so, leave it to the arbitrator. Fine.
Good enough. So, my
Doesn't
lord,
matter.
fortunately, my lord, we are not on existence today.
And
Because
we are on
the larger issue.
way out instead of
We are on not even we are on stamping, my lord, which is one larger area. My lord, we have gone past existence, we have gone past validity, and we have got to admissibility. So, my lord, today we are debating what is to be done. Stamp. So that is in fact, my lord, there can be no dispute. I say this with authority, my lord, that an unstamped agreement exists and is valid in law. My lord, they cannot be disputed that that transaction is a valid.
Repeat yesterday's question, whether under section 35 of the Stamp Act or 34 of the Maharashtra Act,
34 and 33, 35 I have to answer, my lord.
whether it amounts to adducing evidence when an applicant in section 11 produces the agreement, whether it is adducing evidence, whether it's in that sense it is straight away attractive.
My lord, whether 33 and 35 are attracted or not. Can I, my lord?
First of all, in section 11 application.
Yes, your lordship had asked me that question, my lord. You produce the document. Is that admission into evidence or not? And whether as a result of that, 33 and 35 engages.
That's the only issue.
Right. My lord, I will go one step behind that and I will say that 33 and 35 is not at all triggered. And I will show, my lord, how 33 and 35 is not triggered, my lord. So, my lord, this is the 246 Law Commission report. I have also set out, my lord, in the note, the relevant pages of the high-level committee. This is Sri Krishna committee, my lord. I am not going to read it in the interest of time, my lord, but that is at page 84 to 87 of this volume. The report starts at page 75. The relevant paras are 73 to 76. My lord, it is in the note. I am not reading it out. It doesn't advance matter much further.
Yeah.
But it also says that SBP has been overruled. You have to consider the aspect of speed, etc., etc. In fact, now under the new regime of high-level committee, the courts are completely excluded. from the appointment process.
Yeah.
There is a complete exclusion of courts from the appointment process. Courts will come in either at 16 or 34 stage to, my lord, give the final stamp of approval or rejection. So it's not that the courts are excluded. The intervention of the court has been, my lord, shall we say, deferred, or the application of mine and detailed understanding of the courts has been deferred, my lord, to a later stage. Because that is, my lord, how the legislation is structured. That first you go to the arbitrator and decide, and questions of jurisdiction, those 4 headings, my lord, I'd shown, whether it is subject matter arbitration, etc., all will go there. Now, my lord, 3 judgments. Your lordship is looking at Mayavati. May I just show the other 2 judgments before that? My lord, Duro Felguera. Please see Duro Felguera.
Which volume?
My lord, volume 2.
It's at page 64.
Duro Felguera
There are page 64.
yes,
of it.
has been approved in Mayavati specifically. So, my lord, I just want to show the reasoning. So, Duro Felguera begins at page 64. My lord, the merits of the matter are really not much of consequence here. I have put it out in the note. There was a supplementary judgment by Justice Joseph, Korean Joseph, of which 4 or 5 paragraphs are important.
Yeah.
Because they have been approved, and that is the approach which has now been accepted. Justice Korean's judgment starts at page 94.
That is the first judgment.
Sorry,
That is the first judgment on 6A.
that's the first judge. That is the first judge. Your lordship.
6A has been interpreted in number of judgments
Right.
in a different way.
Right.
That is for the guidance.
This is the first one.
First,
First
we are only on the limited issue.
Stamp.
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 If it is unstamped, insufficiently stamped, what will be the scope
Right.
for the court on the social level?
Right.
Let us confine back to that.
Right. So, my lord, I am saying that this is the test on other things.
Multiplying on a different
I know.
context which
I
is
agree.
required for us.
It's not. It's not.
Otherwise, this is an unending debate.
Unending dispute. My lord, I will
And,
go.
more the discussion, more
More
the
interesting points.
opening the questions to be answered.
Right.
So we confine back to this.
Stamp.
Stamp back.
Stamp. So, my lord, I am showing this only in the context of stamp.
Yes.
I am showing, my lord, 3
But
judgments.
that was not the case in reference to stamp back.
No, my lord, but the proposition which was approved is the proposition which will apply even for stamp.
52, 53. something.
Yes, my lord. I'm saying that's the test. Please apply that test. That's what I'm saying, my lord. It is not on stamp. But, my lord, it gives the test.
Same problem comes in. Suppose it's just sitting in 482. It's just sitting in a criminal revision. Scope is different. But the parameters when we test is not overlapping. And judge is sitting in 226 and 227. And judge is sitting in 227. Parameters are quite different.
Correct.
But when we, as a judge, when we said
Correct.
almost the same parameters go on overlapping.
Right.
And a lot of confusion goes on. The scope in 226 and 227 and 227.
Correct.
Of course.
So, my lord, I am only showing this. Therefore, I said, my lord, I am not going to the facts of this case.
Para 59 is what you want to do.
My lord, 3 paragraphs.
Para 59.
4 paragraphs, my lord. I've noted the paragraphs, my lord. First, he starts, my lord, after analyzing 47, 48. My lord, 48 is referred to in Justice Nariman's judgment at page 94. That's why I'm mentioning.
59 is what is important.
59 is important. My lord, 56 says that this is one of the first cases. And my lord, 59
59 is sufficient.
is sufficient.
That's what we
59 is sufficient. So, my lord, I rely only on 59.
Para 59.
59. The scope of power under so-and-so was considerably wide in view of the decision of the SPP. Position continued till the amendment. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. The legislative policy is essentially to minimize the court's intervention. And intention ought to be respected. This is, my lord, according to me, nothing more seems to be irrelevant. Thereafter, my lord, the next judgment I've referred to, my lord, I've referred to in my note, my lord, is Uttaranchal Pur Sainik, which, my lord, which also deals with this aspect. 2 paragraphs there, and then straight away my Uttaranchal Proof Sainik is in page 127. This is, my lord, I believe my Lord Justice Rastogi was also a part of it. Page 127. No, really, the relevant paragraph is 7. This starts at page 127 of this compilation. It's two-judge bench. Paragraph 7, my lord, really deals with the issue, because the issue there was whether limitation should be gone into or not. But my lord, what is important is, I have mentioned the paragraphs. It gives the history of 2015 amendment, etc., etc. And then, my lord, 7.7 Law Commission report, and 7.8 it relies on Duro Felguera, and my lord, 7.10. In view of the legislative mandate contained in 11.6a, court is now required to only examine existence. All other preliminary or threshold issues are left to be decided by the arbitrator under 16, which enshrines the competence. And then, my lord, 7.11 explains in some detail the competence principle and said it is subject to the court's control. It is not that it is completely the arbitrators like tilting at windmills can do whatever he wants. There is some court control. And my lord, 7.12 is also important. The legislative intent is party autonomy and minimal judicial interference. Also at the pre-reference stage is also emphasized on 7.12 and 30. No, this is a little more elaborate. And then your lordship comes to Maya. 115, which your lordship was, my Lord Justice Joseph was already looking at. This case also was not a stamp case. It arose out of accord and satisfaction. And my lord, the importance of this case, if I can say, is that it sets out in one place the legislative history. So it can easily be, my lord, paras 8 to 14 set out the legislative history. The finding of the court, my lord, before your lordships see the finding, please note paragraph 10, the legislative overruling of SBP. Lord, please come to para 10, 125. This being the position, it is clear that the law prior to the 2015 amendment that has been laid down with this court, which would have included going into whether accord or satisfaction takes place, has now been legislatively overruled. This being the position, difficult to agree with the reasoning concerned in the aforesaid judgment. And as section 11.6a is confined to the examination of the existence in italics of an arbitration agreement, and is to be understood in the narrow sense as laid down in the judgment in Duro Felguera at 48 to 59. So, my lord, these are three general judgments, my lord, on the scope of 11.6a. Apart, my lord, from Vidya Drolia, which I will deal with separately. So, my lord, with this aspect, I'm not going to show World Sport Group, my lord. I mentioned World Sport Group. World Sport Group was a case under section 45. And in World Sport Group, three separate expressions were defined: null and void, inoperative, incapable of being performed. So, my lord, a non-stamped document at the highest may be incapable of being performed. At the highest. Even that, my lord, may not be correct because it's a curable defect. But it is certainly not null and void. My lord, in fact, this phrase null and void, which is used in part 2, is actually only void. Null and void means void. This is in the English text, it is null and void. In the French and Spanish text, my lord, it means void. So if an agreement is void, then perhaps, my lord, it will go to validity. So, my lord, there is narrow existence, then there is validity, and my lord, there is admissibility. So, my lord, we are at stage 3. So, my lord, existence, certainly it exists. I would say that a unstamped document is also valid, i.e. it is not void. So, my lord, so far as 11.6 is concerned, 6a is concerned, one word I would like to emphasize, my lord, which is confined. the language of 11.6a, my lord, I understand that after the recommendations of the Law Commission were placed before the government, my lord, there was some rethink and 11.6a was rejigged. And the expression is, first word which is used is confined. And confined, your lordships will note, Lord, we have mentioned some dictionaries, etc. Confined means circumscribed. Confined means, not Lakshman Rekha. Confined means that it is within that limit. So the 11 court will have to confine to the examination of existence and nothing more. So, my lord, this is also part of the legislative policy.
When we come to section 20 of the Contract Act,
20 of the contract. Not voidness.
voidness.
My lord, none of the section from 20 to 30, which includes contracts which are void, cover an unstamped agreement.
That's right. We are asking you for some other purpose.
Right.
Supposing a contract is alleged to be void as distinct from voidable.
Void ab initio.
Void ab initio.
Void ab initio.
If an agreement is void ab initio, can it exist?
My lord, there is a little gray area there. My lord, two words have been used. One is existence, one is validity. According to me, my lord, it may existence may encompass validity also. So, my lord, it may be argued that existence includes validity, though the legislature has used two different words.
What will be the effect of the contract being declared voidable under the Contract Act? Because
Those are the next few sections, my lord. That is an option which is open, my lord. I'll show those sections of the contract.
Would a voidable contract, can it be said that it exists?
It exists, my lord. It certainly exists.
It exists.
It exists. So, my lord, subject to the contract being void, my lord, and therefore, at least in my note, I have, my lord, submitted that formal validity will have to be established to some degree before the 11 court. You will have to, at least as an 11 judge, see whether you know their basic ingredients are.
You got a finding finally.
My lord, then we are back to.
You got a finding.
Then, my lord, we are back to the other question.
Yes, that's correct. So
Of-
ultimately,
of-
11 court. 11
My lord,
court
then we are on the standard. My lord, one is scope, one is standard, my lord.
A sort of nebulous area.
You
You
then.
say leave it,
But, my lord,
but it should be left open. There's a whole problem arises where
if it's not left open.
if it is not
If it's not
left open.
Yes, absolutely. That's the only way really to reconcile 11 and 16. It'll have to be left open. Otherwise, my lord, then whether one likes it or not, a court is a court, my lord. Then an arbitrator will be very chary of however much we say that Article 16 is very wide, give it its full play. No arbitrator will really then want to revisit what a court has done. That's the practical implication. Triple right. Well, I just it's not in the compilation. I'll just tender this for the purposes of completion. We mentioned it at page 23. The word confined, what it means. Wait. Second last entry on the right column. To keep within circumscribing limits, to restrict. Just, my lord, it's just an understanding of the meaning. As your lordship said in the other matter, one has to confine to only, my lord, the guidelines. Here I have to confine only, my lord, to stamp act.
Once made, we have to remind ourselves that while deciding applications of section 11 is not a court.
It's not a, my lord, full-fledged court of record in the way that your lordships are today.
So this back of the mind goes on all the time. That sometimes creates a lot of problems.
And, my lord, the instinct of the judge is to decide. If the judge sees, my lord, there is a lot of criticism of our courts that we are intervening. Lot of criticism. But my lord, my personal view, and I want to make this clear, is that the reason that the courts are intervening is because there's serious defect in our legislation in the Arbitration Act. We have eliminated 16 appeal. We have, my lord, not looked at 34 properly, my lord. There are any number of reasons where the courts are intervening because we have not got the proper statute. So it's very easy, my lord, to blame courts because courts will interfere or intervene if there is injustice.
One suggestion which I heard was, when a court deals with section 34, the court should not be burdened with the obligation to furnish reasons.
Permit?
Furnish reasons. Because what is happening is,
That
told that in all these courts, matters are pending for long periods of time where you hear elaborately, something like the SLP jurisdiction.
my lord, it should be a
Where you
shorter
say
order.
dismissed, that's it.
But my lord, if the High Court start passing shorter orders, your lordships will say, and 136 or 37. My lord,
37 itself.
yes, my lord, please see the section 11 orders which are coming to my lords. They are all 30, 40 pages. Because the High Courts have to write such an order to show that I have conducted quote unquote an
Application of mind.
intense yet summary estimate of section 11.
And when the party places a
Lord,
document
we are
that's
all-
of 1,000 pages,
We are all
and
responsible.
then you ask the district judge or the assigned officer, look into those 1,000 pages and report an application of mind. God knows where the application of mind will come
What happened?
in deciphering 1,000 and more pages.
You don't have.
That's the issue.
And then in 37, it's all scope open. If you are not assigning reasons, in 34, 37 is open.
My lord,
And the court has no business except to remit the matter back to the Supreme Court.
and then, my lord,
Now it is not possible.
the other problem is we have only ad hoc arbitration. We don't have institutions, and we don't have, my lord, institutions which we respect. So normally in other jurisdiction, if the institution is respectable, then you look at it, and they have also had a look at it. Then you don't really want to interfere. You can, my lord. But today we have so many very peculiar awards also. My lord, one has faced them where you know that there is something that is not.
That is something we look into 136, who is the judge who will pass the order. But that is not the way it was. That is not an advisable situation. You have to look into the merits, not the author. But we look into.
Now, my lord,
This, one more question.
One
I
more.
just wanted to, when we saw it, if just come to section 35.
35.
The question which we troubled you with,
Yes, ma'am.
namely whether its purpose is actually to deal with the aspect of educing evidence.
Right,
There
ma'am.
is another aspect. to it.
Right, ma'am.
This is section 35 once more here.
My lord, could I address your lordships on 33 and 35 now?
There you can.
So that, my
But
lord,
we just wanted you to
Yes,
read this. It's a
35, yes.
Specific issue,
specifically.
because it's important to the question at hand.
Yes.
You just read that.
No instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by any such person or by any public officer, unless such instrument is duly.
So the question is, it actually interdicts to receive, authority to receive evidence, nor shall be acted upon.
Correct.
Now, when section 11, under section 11, now.
Are you acting upon it? No?
Are you acting upon?
Right.
At
No,
least.
At least acting on. My lord, that this is my response, and I'll give it now, my lord, because I can understand that 33 and 35 is certainly bothering my lord. I'll give a response, my lord, not on the larger plane. I'll give a response on the sections. My lord, the section triggers. 35 only triggers if there is a finding that the document is not duly stamped. So, my lord, after the comma, unless such instrument is duly stamped. So, my lord, there has to be first an inquiry as to whether ABC document is duly stamped or not. Or am I making myself clear?
No, the point is, we were actually, stuck up with the concept of admissibility, inadmissibility, flowing from section 35. But we thought that it goes a little further. Section 35.
Or acted upon.
or acted upon.
Yes, my lord, it goes further. No doubt about it. No doubt. My lord, they are two independent limbs.
So then the next
I,
question.
my lord, I'm answering the question in a different way.
No, then the next question will be, the theory of unenforceability,
My lord,
which you took exception to.
Yes.
You said an arbitration agreement is very much enforceable.
My lord, I say it exists.
It exists.
It exists.
No, it exists.
It exists.
But can it be enforced if it cannot be acted upon?
My lord, it enforceable.
And when you talk about acted upon,
My lord, enforceable at law.
It should be understood as
My lord,
acted
that
upon
phrase.
in a court of law.
Enforceable by law, my lord, is a phrase used in the Contract Act. I'll come back to that, my lord. Please, there's a very interesting, my lord, there is a particular part of Justice Nariman's reasoning which goes on the phrase enforceable at law. So, my lord, I'll come to that. But I have a different answer to 35. I have a very different answer to 35. My lord, 35 will trigger. 35 is a bar. It's a bar, my lord. It's a bar. Subject to exception, my lord. I'm leaving this. It's a bar, my lord. 35 is preceded by 33. 33 is, in a sense, the same side, other side of the coin. So when the document comes, there is a duty on the judicial authority or the arbitrator to look at the document and make an inquiry. The sequitur is that if the arbitrator or the judge or anybody finds that it is not duly stamped, he can't even act upon it. So, these are two parts of the same legislation. So, my lord, the bar comes because, my lord, so 35 is the bar and 33, my lord, your lordship, go back to 33.
Let us put it slightly different. When a person, without taking care to get it impounded, without paying up the duty with the penalty, he rushes to an 11th port. He rushes to 11th port with an unstamped or insufficient.
Unstamped. No, let us take unstamped.
Unstamped. And no doubt about that it is a document, is an instrument.
My lord, that's where the doubt is, my lord. Your lordship says no doubt about it. That is where, my lord, I have.
No, you have yourself said.
My lord, I'm answering myself, my lord. Your lordship.
Because I see yesterday you say an agreement to refer, even if it is a separate independent agreement, has to be stamped. So we begin with an unstamped agreement.
My lord, I'll go one step.
What you're saying is something different.
The
simple question is, can you
act upon?
Act upon?
My lord, I'll answer.
Will not the court be said to be acting upon?
Right. I'll answer. My lord,
forget about evidence.
Forget about it. Forget about it.
Very act of referring to the arbitration.
My lord, I have an answer on acting upon it. I'll come to that. But, my lord, I have a preliminary point, which is that, please see 33.2. Please see 33.1, 33.2, and then 35. And I'll explain, my lord, why 35 bar is not even reached. No, 35 bar has to be reached. 33.1 says, every person having by law consent of parties authority to receive evidence, every person in charge of public. Now, this is the same language as 35. Except an officer of the police before whom any instrument chargeable in his opinion, which duty is produced or comes to the performance of one, shall. Now, my lord, these are the critical words. If it appears to him that such instrument is not duly stamped. Now, my lord, the examination by the person is to examine whether such instrument is duly stamped or not. That examination is found in, my lord, 2. For that purpose, every such person shall examine every instrument so chargeable and so produced before him in order to do what? In order to ascertain whether it is stamped with a stamp of the value and description required by the law enforced in India when such instrument was executed or first executed. So, my lord, if 33.2 is triggered, then 33 will follow. And if My lord, if I have to conduct this examination, then I will come to a conclusion that it is not duly stamped. And then if it is not duly stamped, it will be barred. So, my lord, the steps are different. We have jumped 3 steps. So, my lord, my submission is that 33(2) examination is not to be done in 11.6. That's the submission. So, if 33(2) examination is not to be done in 11.6, my lord, neither will 33 apply, nor will 35 apply. 33(2) examination is to be done, yes, by the arbitrator. So, my lord, it is not that this is being escaped, but this examination, if you are not required, but therefore I come back to scope of authority. It is not within the Lakshman Rekha or scope of authority to undertake this examination. Because, my lord, if your lordships do undertake this examination, I have confidently today told your lordship, it is arbitration agreement is to be stamped. Till yesterday, my lord, there was a 3-judge bench judgment of this honorable court which said arbitration agreement has not to be stamped. Today, there is a controversy inter parties on what is the value of the stamping, what is the person to be paid, what is the dispute. So, my lord, if 35(2) is to be done by by the 11 court, the bar in 35 will hit me. But 35 bar will not be triggered because 35 will not apply. That's the submission.
Can you not harmoniously interpret 11.6a with section 35 as we are duty bound to do? Both are central enactments.
My lord, 35
No,
was.
are we either we close our eyes completely to 35?
Your lordship is not closing eyes to 35 completely.
We are not.
No, you are only deferring it.
No.
You are not, my lords are not closing eyes to 35.
The point is that we are bidden to not act upon the document
Unless it is duly stamped.
unless it is duly stamped.
But how?
It is stamped to begin with.
No, my lord.
Duly
It says
stamped is okay.
it is
In a
duly
case where-
stamped.
In a case where there is no dispute that the document has to be stamped, number one, we are taking that case alone.
My lord, then we are now going beyond the existence of the agreement.
No, that we are telling you. See, when 11.6a was enacted, it
Right.
was enacted with a particular purpose. What was the legislative history, judicial history, SBP, 7 judges, earlier
My lord,
judges?
the
They
purpose.
were going into 3 categories of cases. They thought that all of this is covered under section 11.
Right, my lord.
So actually they trimmed the jurisdiction, as it were, and said you have to only look into the existence of an agreement.
Now, my lord, by looking at into the
Now,
existence of
existence
existence, my
the
lord.
existence of an agreement,
Right, my lord.
which we have to also bear in mind. In the same breath, we have to also say that we have to act upon it.
My lord, your lordships are assuming that that bar is there of acting upon.
That's right.
I am saying that bar, my lord, it is like you have not even reached the point. My lord, this 35 will trigger only, my lord, because this expression duly stamped, my lord, has been explained in 214. It is not stamped, unstamped, my lord, it is duly stamped. So, my lord, if it is duly stamped, then there is no bar. It may be in cases, my lord, a document may not require to be stamped at all. I have given an example. So, my lord, the question is, will this court, or not this court, my lord, the 11th court, be required to make that inquiry? Yes, if your lordships feel it is required to make the inquiry, what are the consequences which follow? That is certainly one view, my lord. But having used the word existence, having, my lord, curtailed it from admissibility, validity, existence, my lord, confined. It is confined, my lord. It is a list which has to be ticked off. Is there a valid agreement? My lord, if it is not then the meaning of the word, my lord, confined will go.
See, the validity of the agreement, no difficulty.
So, my lord,
You have to not confuse an unstamped agreement with an invalid agreement. It is not. You are right.
right, my lord.
In
So,
that
moment
sense,
it is
not,
valid.
It is not an invalid agreement. It is.
It's a valid agreement, no?
It's a valid agreement.
It's a valid agreement.
No, what you're saying, it is a valid agreement.
It's a valid agreement.
It exists.
It exists.
It exists. It's
Right.
not as if it is void.
It's not void.
Both of that, you're
So far, so good.
The question is, when section 35, which is equally the mandate of Parliament,
My lord, 30.
says that don't act upon it.
Unless stamped.
Unless it is stamped.
But unless it is stamped is an issue which has to be decided.
In a case where,
My lord,
in a case where
that's a
nobody has
presumption, my lord.
in a case which we are giving us, that all these, because the three judges bench which is referred, it is wrong in saying that an arbitration
So, my
agreement,
lord, that's the issue, my lord.
if it is completely unstamped,
My lord, that
there
is
is no
the issue.
dispute about it.
That is, my lord, that is the issue, my lord. The question is, your lordships are therefore assuming that 35 is complied. I am saying you have to look at 35 and you will have to look at 33. I am coming to acted upon, my lord. On the phrase acted upon, my lord, how that works. I'll come to that, my lord. My lord, also your lordships will have to keep in mind, my lord, Stamp Act is 1899 when we had an 1899 Act, my lord. We have progressed considerably with the arbitration. There have been 1899 Arbitration Act was there. Lordships will have to give some interpretation which will make both workable.
Exactly.
Right? Now, my lord, I am suggesting that the only way or the practical way to make both workable is to leave this decision of stamping good, bad, indifferent, high, low, whatever it is, to the arbitral tribunal. Who has the power? There is no dispute he has the power. The sections say so. And he has to obey the law. So, my lord, the other view is, let's test the other view, my lord. The other view will necessarily mean that the legislative, my lord, intention of appointing an arbitrator merely on the existence of an agreement, whether prima facie final or whatever it is, and limiting the scope of the authority will go for a toss. No, that's the reality. That is what had weighed, my lord, with the full bench and my lord, and it is not our say so. It is the legislative history and the reason for bringing the amendment through. Today, my lord, who is raising this question? Let's put it a different way. Who is raising the question of non-stamping? The person who does not want to go to arbitration. It may be that he has to pay the stamp, but he doesn't want to go to arbitration. So, my lord, or take my lord, case where you want, which we are not concerned with, the interim release, section 9. We are not concerned in this case. Who is raising the non-stamping defense, my lord? And how do we balance it? Do we, my lord, put a chokehold at the stage of 11.6 when 33 and 35 can be equally, my lord, read? My lord, I ask myself a simple question. Is the 11.6 judge required to do 33.2? Is he required to do this or not? If he is required to do this, my lord, this will go against 11.6. If he is not required to do 33.2, then 35 will not even come into the picture.
So according to you, the conundrum is only this. Who is to decide?
That's all, my lord.
Who is to decide? And according to you, the section 33(2) of Stamp Act, that examination need be done only at the stage of first 16 by the arbitrator.
Not at the stage of 16, my lord. Right at the beginning. He doesn't even have to go to 16. He has to do it on virtually.
By the arbitrator only.
Yes, on day one. Because, my lord, moment to have an unstamped agreement, none of the substantive rights can really be.
In short, 33(2).
33.
That need be looked into or examined only by the arbitrator.
And that will work well, my lord. It will work in every way. It will work. The revenue will be protected. The document will be impounded. The decision will be there, subject to court control. There will be no delay. Why should, my lord, I put it in a different way. Why should the court burden itself with this headache? Unless your lordships interpret as this is a gun to the head, you have to do it. So, my lord, that's the question. Why should the court burden itself?
Do it completely, complete circle. For the extent your contention.
Right.
And we also had prima facie what to say is workable. And is a speedy
Right.
disposal of the applications and let the parties come to arbitration. Ultimately, what will happen? From our 11th jurisdiction, it will transfer to the jurisdiction of the arbitrator.
Yes.
Now, obviously in the written statement that will come forward, the first objection would be unstamped or
Yes, yes,
insufficiently stamped.
that will be fought out.
Now they will say you can't proceed, must get an inquiry of 33 to
No difficulty.
and then 35
No
and
problem.
thereafter, meaning thereby, then what we are going to hold and record a finding will be stuck by the arbitrator and then he will take another.
No, Your Lordship will not record a
I-
finding.
No.
Your Lordship will not record
we are
any
not saying.
finding.
Suppose if we take an inquiry
Yes,
and
ma'am.
record a finding
Right.
in reference 33 to or whatever it is, and say, no, sorry, whatever the document is fully stamped, nothing doing. That chapter is over, let the parties address on merits before the arbitrator. This is one theory.
One theory.
The second theory, as you say, is sorry, you don't intervene in section 11 jurisdiction. Leave it to the arbitrator to examine. All right, we agree. Now, the first question would obviously the person who doesn't want to go for arbitration
We'll raise it.
will raise it
Your
definitely.
Lord, three things will happen.
Same man. So,
Aren't we coming to the same conclusion? Is what Your Lordship is saying.
we have a different point. So, when the matter is now instituted before the arbitrator, and the person who is not inclined to go for arbitration,
We'll raise the point.
definitely raise it.
Definitely raise it.
Obviously. Now, the arbitrator will also act in the exercise. Yes,
He will have to undertake the exercise.
To 33.
Yes, Madam.
To inquiry, and then 35 as to what should be adequate
Penalty,
stamp, or whatever it is.
penalty, stamp,
Now,
whatever.
now, the legislature also says simultaneously the arbitrator should also conclude
Right, Madam.
within 1 year plus 6 months from the service and all.
No difficulty.
Now you will find in the system which we are today prevalent, the arbitrator will be stuck to proceed unless that document in reference to which the arbitration proceedings are to commence is not being properly and adequately, insufficiently or sufficiently
Lord,
stamped.
I'm doing some arbitrations like that. I'll explain more what
So,
happens.
so
I've
what,
seen that.
what comes to us, subject to what? Are we not to step in or leave it to the arbitrator to
Well,
take a call and
let's
do it in his own way?
let's play this out.
Or
Should Your Lordship not decide it?
not decided, right?
So, my Lord, let's play this out. Supposing this very point of unstamped is raised before my lords, right? My Lord, in practical terms, this, my Lord, one is the interpretation of 3335. In practical terms, what has happened, my Lord, and I can vouch for this, Delhi is taking a different view. In Bombay, virtually everybody is raising this as the defense. So you file a reply, then you file a rejoinder, then you hear the matter after a year. No, this is the practical reality.
That's correct.
This is one version, my Lord. So the arbitration is stuck. You've not got an arbitrator yet. The other, my Lord, option which I am suggesting, because I am appearing in some such arbitration, where there is no dispute here, my Lord, there is no section 11. You straight away go before the arbitrator, the other side has raised the point. My Lord, two or three things have happened. One is either the arbitrator has taken the point, you file your reply, I will decide within a week. Right or wrong, I will decide. Whatever I decide either you are liable, he is liable, or I decide it is 10 lakhs or 5 lakhs. That's also a dispute in the arbitration itself, because you can pay and recover, my Lord, in the arbitration itself. So one stop, my Lord, solution. Secondly, my Lord, what happens in some cases, once the arbitration starts, one or other side simply pays it and then adjusts it at the end in the award. Many cases before, my Lord, one case, the petition has been withdrawn because people have, my Lord, because it has been pending, they've simply paid and got along. Like in this case, my Lord, they have overpaid according to them. So, my Lord, which is the better option? Should this court be required in law or otherwise to decide this? Because, my Lord, always the court wants to decide every point, or leave it to the arbitrator where this will be played out at least faster, my Lord. And it will come out of the system. It may go back into the system later in 34, but it will come out of the system. My Lord, ADR, my Lord, we are now speaking of international arbitration, hub of arbitration. If Your Lordship sees some of those articles, particularly one which is written, the sort of language which is used, my Lord, my blood was boiling, but I put it there. My Lord, there are, if we overextend or increase the ambit of 11, there is, my Lord, an issue much above and beyond. My Lord, Your Lordships are restricted to stamping. But if a constitution bench takes the view that 11 includes, my Lord, stamping, then it may legitimately also be argued it may include limitation, it may include X, it may include Y, it may include Z. Where does one draw the line? So, my Lord, that is why, my Lord, I am advocating the narrow meaning. And that is why, my Lord, I am advocating that 33 and 35 actually does not trigger. My Lord, on acting upon, there is a My lord, there is another argument. There are one of the articles, my lord, deals with this acting upon thing, which Mr. Rebello has written an article. My lord, he has dealt with it in some detail in volume 4 on this acting upon aspect. But my lord, my understanding is that this is not an inquiry you should undertake. You should not even say what I am saying, my lord, what I said yesterday, that this is wrong. I had to say it is wrong because the judgment is wrong. No? But it is not something you should be looking towards. You should not be looking towards stamp. It's not your headache at the moment.
Something, it is a jurisdiction for the arbitrator to decide how to proceed. Because law of evidence is not applicable.
Law of evidence. But, my lord, in fairness to this, the arbitrators enjoined by section 35, because he is named as a party by consent. So he will have to look at it. He cannot avoid the substantive law.
No, but the law of evidence is not applicable.
Law of evidence is not applicable. 19, Lordship is right, law of evidence is not applicable. But he will have to look at it. Well, I'll give an extreme case. Both parties go. The document is unstamped. The arbitrator still has to look at it because it is his duty to protect the revenue. Supposing neither party raises it, it happens. Or if he ignores it and it's taken in evidence under 36, it is waived. It's a curable defect. It's not a big deal, Mano.
I mean, you're rejecting a disputed case as a premise for your argument.
My lord, I am suggesting all cases are disputed because
Supposing the party who's an applicant under section 11 himself admits, yes, it is unstamped. It really doesn't bear the stamp it should. He admits, he doesn't say he has absolutely no case. What should the court do under section 11?
my lord, if he admits, then he has to pay the stamp duty. My lord, that is on admission, my lord. But admission will not make, my lord, the. But then the question is, my lord, should he be at all asked the question?
If he volunteers,
I don't think, my lord, anybody volunteers anything, my lord.
It can be other way around also.
You have to ask the question.
Either to pay tax or.
You will say, all right, I volunteer to have a stamp of 20 rupees.
No, the
And
other
then
side,
the other-
other side objects.
Others,
Side
not.
objects, and he says, yes, it's correct.
So right. But is the judge required to ask himself this question? Answer, my lord, if he is, 33 and 35 may have some conflict. If he is not, then my lord, that's why it is a very limited jurisdiction. You see agreement, you see, Lord, I'm sorry, they give you a motor.
Answering the question. If it is unstamped, what kind of 33(2) inquiry is required? If insufficiently stamped, you need inquiry. But if it is not stamped, then what 33(2) inquiry you want?
Well, Lord, I'm saying that.
No dispute at all.
Well,
What kind of 33(2) inquiry you are asking for?
I am not asking for the inquiry. I am saying that you please don't get to the 33(2) stage. Your lordship is assuming so many.
oh, but 33 to 35 requires the first point of judicial contact, that judicial officer to see that factor.
My lord, that's the point. In normal cases, yes. In all other cases, yes. The judicial officer, regardless of the parties before him, must see the document and must address his point to stamping. So many cases, my lord, in tax matters we've seen in the High Court, neither party says anything. The judge says it's unstamped. You first cough up the money. But my lord, is that general test to be applied to
With an 11.6.
That's the only question, my lord. Generally, yes. Yes, my lord. Of course, he has to look at it because he's a judicial officer, my lord.
So you are relying on that existence in 11.6.
Confined, my lord, to
To
examination. My lord, the word used is examination.
So according to you, if in the agreement there's an arbitration clause written, then it is in existence.
It is in
Whether
existence
it's
for
stamped
the
or not.
limited purpose of subject to it being, my lord, patently void. There may be some extreme situations, maybe, my lord, unstamping may come to, but it's not patently void, my lord. Supposing it's absolutely illegal, then your lordships will not appoint. It is not that there is, that is that thin line which has been drawn in Vidyadrolya. The question is, are we expanding the circle? That's the only question, my lord.
So how does Justice Nariman approach it and hold
Let
that?
us show the, my lord, let me now show the three judgments,
Yes.
three, four judgments.
Yes.
where according to me, my lord, there is a problem. Let us first see, my lord, Garwari. Only 3 or 4 judgments.
That's it.
That's
Maybe
what,
they will
what
also
there is
recommend.
to it. And then, my lord, actually, Vidya Jolia, I would beseech your lordships to look at a little carefully, because there are all sorts of things in Vidya Jolia which were perhaps, my lord, not required and are causing, because let me first place Garwari.
Yeah.
Let me first. My lord,
This is Nariman's judgment, which is that.
just Garwari.
Garwar.
Garwari.
Let's see that, because that is what is called its worship finally.
The judgment begins at page 8. Justice Nariman's judgment begins
Yes.
at page 8.
Let's straightway we'll go to the discussion of this.
My lord, I just want to, if your lordships permit me, since
Yes.
it's a reference judgment,
Yes.
two, three paragraphs, my lord, because I believe it's been put very well. Please come to para 3. At the bottom, page 8, the question is whether 11.6a, which has been introduced by way of arbitration conciliation, has removed the basis of its judgment so that the stage at which the instrument was to be impounded not by the judge hearing the section 11, but by arbitrators appointed under section as is being held by the impugned judgment. My lord, in fact, now thereafter there was a full bench of Bombay High Court which affirmed the view of the High Court, which was overruled. I have put the Bombay High Court judgment also, because that has some interesting passages, my lord, full bench. So, my lord, that. Then, my lord, please come to para 5. Miss Niyati, learned advocate appearing on behalf of respondent, referred us to section so-and-so, so-and-so, so-and-so in particular, made it clear object of the Amendment Act was to confine the court hearing, section 11, to examination existence, nothing more. She made a distinction between validity and existence. But I am not making this distinction. Argued the provisions are fiscal measure intended merely to get revenue, if at all will go to validity. According to me, Lord, it doesn't even go to validity and not to existence. She relied strongly upon certain judgment, made it clear arbitration agreement independent. So long as it in writing exists in fact, so the whole object of amendment would be defeated, as otherwise a mini trial would be conducted at the section 11 stage. Also relied upon 11.13 of the Act, application has to be disposed on 60 days. Equally, according to her, no prejudice would be caused. Arbitrator was to commence and then impound. Also argued in the present case, appellant has to pay. So, these were the arguments which were made. I adopt some of these, submissions. Thereafter, the Justice Nariman sets out various provisions of the Act, and then from para 8 to 14 is the commentary, my lord, which is in respect of the history of the legislation, which starts at page 14, para 8. Law has, prior to Amendment Act 2515, has a checkered history. And then, my lord, at para 12, he comments.
29, if you don't like.
My lord, may just see 19 to 22 and 29.
Yeah.
And show that, but just 19 to 22, my lord, are very, very relevant. My lord, first, before that, my lord, I would ask your lordship to see para 18, because I believe, my lord, this is where one error has crept in. 18 is para page 22. It will be noticed from the aforesaid judgment when arbitration clause contained in arbitration or conveys different consequences ensure depending on whether agreement conference is registered. It is settled by SBP and company that section 60 of the 1996 Act has full play only after the arbitral tribunal is constituted without intervention of the court under 11. My lord, this was the old view. This is one, my lord, problem with this judgment, that we have this going back to the old view. And on this basis, the 3-judge bench, my lord, at page 2, page 24, rejects the contention in view of the law laid down by the 7-judge bench, difficult to accede to the argument made by learned counsel on behalf of respondent. Section 16 makes it clear arbitration agreement independent existence must be applied by delay. No, I would respectfully submit.
After that. Will be 10 minutes. I have a meeting. So About 10-15 minutes, 2:15 you can come.
There is some other.
That's right. After that only, because
Right.
we'll have to do that.
Right.
We're just telling you we're there, we'll come 10 minutes.
No,
We have a-
Deep,
a meeting with them.
deep.
Let them make it clear. Which one you'll take first? 210